Very good evening to all of you. I intended to start at 5 p.m. as I stated to you, but my alarm could not help me when I decided to take a nap. So sorry about the late commencement. But just some housekeeping rules. As I sent you earlier notice on the various platforms that because we have uh, virtually 28 days or 30 days, so to speak, to go in terms of when you actually write your uh, examination as far as the entrance is concerned. I I'm a very busy person, but I'm prepared to meet you every day, maybe for 1 hour to 2 hours in the night. And the way I'll do it, of course, if you cannot even make it because maybe you are working or you some unavoidable things making it impossible for you to be present. I think that you can always go back to the recording and play it back uh, so that you are able to probably get some assistance from what we discuss. So that way, then it's convenient for you and also convenient for me in terms of like the timing, meaning that if it's not the timing is not good for you, you don't have to worry. Uh, what we do will still be there, so that anytime you want to know what we did, you could also go and actually um, play it back. So let's take note of that. So the weekdays ones are the most of the weekday ones will usually be in the night. And usually I think that it's usually either 8:30 to 10 or 9 to 10:30 as the case may be. By which time all of us will have returned from our various works, and then we are able to um, do what we need to do and then get learning. So please, let's take note of that. And because of that, what I intend to do is I think we have 7 days in the week. So every day we do probably, on my part, I will just take an aspect of one of the models. And then we do questions, when I'm done with what I want to tell you for that day, you also be at liberty to raise up anything that you want us to discuss so that we're able to cover some productive lessons. So maybe Sunday, we do Ghana legal system. Uh, Tomorrow being Monday, you probably do another thing, maybe contracts. Tuesday, constitutional law. Wednesday, land law. Yeah, no, I think the Wednesday may be criminal law because I have an arrangement with my friend who is the special prosecutor to come onto our class as he did last year, to discuss some aspect of criminal law we do, because he is an old-time teacher of criminal law. Yeah, and then Thursday we do the land law, and then Friday we do thoughts. I think you have covered all the subjects, so that Saturday we could probably do like just a across board, like without any specific subject as it were. Yeah, so that is what we will do. And so we start. And I will encourage you when you are learning to know, learning go with dependence on God. So you work hard, but you also depend on God to guide your understanding, retention, that you are successful. So invite the Holy Spirit. Come, Holy Spirit, divine creator, true source of light and fountain of wisdom. Pour forth your brilliance upon our dense intellect. Dissipate the darkness which covers us, that of sin of ignorance. Grant us a penetrating mind, to understand a retentive memory and method, and ease in learning, the lucidity to comprehend, and abundant grace in expressing ourselves. Guide the beginning of our work, direct its progress, and bring it to successful completion. This we ask through Jesus Christ, through God and through man, living and reigning with you and the Father, forever and ever. Amen. Yeah, so tonight we want to quickly discuss civil litigation, or the overview of civil litigation. And once we are done with that, we go through some questions. And when I am done, I will then take any questions or suggestions or comments that you may have. So just allow me to quickly walk you through what is meant to be a revision of course, what you are supposed to know. As I always say, the assumption is that you've learned these things already. Our efforts here are just to help you to revise what you've learned long ago. So that is the idea. And that is why we often appear to rush through a lot of things, because this is a revision session. Okay. But then let me also make this announcement. I think at 8:30 or so, I'll be teaching my regular class at KNUS. And then we'll be doing vitiating factors. It's not for Ghana School of Law, but since law of contract is one of the things that we'll be doing, when I'm done, I'll put the link there. If you want to join, you can join, or I'll try and do the recording and upload it on the YouTube so that you're able to join us. Okay, so when we talk about the civil procedure, civil litigation, or the civil justice, we are talking about the additional mechanisms which are available for trying to bring claim against another person that might have wronged us. Of course, when we started Ghana legal system the very first time, we talk about distinction between civil wrong and then the crime. So when we mention civil procedure, when we mention the litigation system, we are referring to the body of rules, the arrangements which are out there that enable us to seek remedy for civil wrong. So when I say civil wrong, I'm referring to breach of contract, I'm referring to tort, defamation, trespass, negligence, whatever. I'm referring to land law, declaration of title. I'm talking about, of course, constitutional law. They are all civil crime, not criminal. Yeah, so we should keep that in mind. So the arrangements which are out there to enable you to go to court and get a remedy, get a relief or panacea is what we call the civil procedure or civil litigation. Of course, talking about that, some of the basic legislative materials which you should have in mind: the civil procedure rules of the High Court, the Court of Appeal, Supreme Court, the District Courts, the Courts Act, the 1992 Constitution, and the various practice direction given by the Supreme Court and the Chief Justice from time to time. So, how does civil proceeding or civil litigation begin? We have to remember that three main ways are out there. We do civil litigation by going through the writ of summons route, or by getting originating motion or notice, or petition, as the case may be. There used to be a lot of various additions, but in modern times, there have been some simplification of how you address several wrongs, and that is why the main ones are just three, as we have talked about: writ of summons, originating motion or notice, and then a petition. So let's say a few words about each of these. When you talk about the writ of summons, that is the formal document by which you initiate a legal suit against someone. So by that, there is issued in the name of the justice, and then it's like the person who at whose instant is issued, actually invoking jurisdiction of the court, invoking the power of the court founded upon the sovereignty of Ghana to command the person that he has been dragged to court to answer certain controversies that are beloved. That's the 12. So that is the essence of the writ of summons. Of course, if you are to go back to the history of the common law, how in the past, the writ system, if you remember, you wanted to bring a claim before the royal courts or common law courts, itinerary judges, how you needed to be able to identify the appropriate writs in which to fit your claim as it were. But again, all those things have been refined, and we just have a simple rate of sermons, which is not tied to any particular type of case, because rate of sermons is the means by which you initiate any case at all in which evidence will be taken and all that, and how to go into it and all that. That is what is important for us. When you get to the law school, eventually there's a course you do called civil procedure, and then you learn more about the technicalities. So what we are doing now, of course, this is a Ghana legal system and legal method, and the presupposition, you are at the beginning of the legal education. So we are just an introduction, as it were. So it's not supposed to be heavily technical, as it were. Of course, we also have the originating motion on notice. And by originating motion on notice, what that means is that somebody is trying to come to court and say that certain provisions in certain legislation or certain law, for example, should be interpreted or should be enforced, and that there is either the rules of civil procedure have prescribed that that is how you should go to the court, or you think that there is no need for you to go into detailed pleadings as you do in the case of a writ of summons. So, and that is why we are saying that it's a very specialized process, and is generally adopted where a statute or an act of parliament provides for the making of an application to the court, but does not provide the manner in which it's made. So if you have a law, for example, the Companies Act will say that where you are complaining of oppression or the affairs of the company are being run in disregard of your proper interest as a member, you could, for example, go to court and make an application. So where it is said they can go to court and make an application, then what that means is that you don't necessarily have to go and issue writ of summons. You will just go by means of what? Originating motion on notice. So motion on notice simply means that you are bringing application. Motion is an application, and notice simply means that you are bringing application which you serve on the opponent against whom you are bringing it. And why originating? Originating comes from the word starting. You are starting the case. So you are starting the case by means of application. So that is why originating on notice as is where. Or so therefore, if you want to know how those type of cases, for example, usually feature in the law report, you either maybe in the matter in which the question arises. So sometimes maybe like contempt, for example, in the matter of contempt application against so and so, or in the matter of application for letters of administration, in the matter of application for probate and things. So those are example of motion notice. Or if you are coming directly under legislation, you can simply, it will just be in the matter of the Companies Act 2019, Act 992, or in the matter of the Copyright Act, so and so and so, and then application by. So that is how it is prepared. And then you accompany that with the normal motion or notice, that is the application in which you state the particular reliefs that you are seeking from the court, accompanied by the affidavit. Affidavit is just a sworn statement in which you try to give an account of matters which you are saying under oath, ground the particular reliefs that you are asking for from the law court. And another example of originating motion or notice is when it comes to enforcement of human rights. You look at the Article 33 of the Constitution, for example, where you are complaining that someone has violated your human rights, you can come to court for reliefs and all that. Now, you do that by means of application. And so that will be an originating motion or notice. Then we also have like a petition. Petition is another way in which you invoke the jurisdiction of the court. And typically, petitions are the most common example when it comes to matrimonial cases, especially like divorce and all that. Then you petition the court and you're asking the court to intervene in certain matters, you and another person. There's a history about why it's a petition and all that, but I don't want to saddle with the history. Otherwise, if you take like a divorce, for example, why it is a petition, you have to go back to the history of the Jessica court, the canon law, the canon law regarding marriage, the celebrity of marriage, and the fact that you needed to petition the bishop, and later on like the king and so on. But we don't want to go into that. All that matters for now is that petition is another example of beginning a civil litigation. And one type of case in which it is done is the divorce or matrimonial. So quickly, let us look at what is contained in the writ of summons. So writ of summons, as I said, is the most common means of beginning a civil action. So it will contain the title of the name of the court, the name of the court in which the case is going. That is the venue. The parties are plaintiff and the defendants. So plaintiff, of course, if you are using the English literature, you notice that since Lord Wolf reforms, we have moved away from plaintiff to claimant. But of course, we in Ghana, we still use plaintiff. But in terms of essence, plaintiff is the same as claimant. So the plaintiff is the one beginning the action, and then the person against whom the case is brought, like the defendant. So you see all this on the writ of summons. You see the location or the address of the person who has been sued and all that. You see it on the writ of summons. And you see if the person is seen by a lawyer, you see that on the writ of summons. Or if the person is sued, you see that on the writ of summons and all that. So as I said, the venue of the action, that is the place in which the case is being brought. Usually, if it's about immovable property or land case, you bring it in the region in which the particular property is located. Or if, let's say, you are talking about the contract, breach of contract, for example, you bring it at the place where the contract was supposed to be performed or where the defendant actually resides. That is where you bring it, and not where the plaintiff resides. So keep that in mind. The place where the defendant resides is what will determine the venue, and not where the plaintiff resides. So that if the defendant stays in Tema and then the plaintiff stays in Kumasi, you don't start the case in the Kumasi High Court. You have to go to Accra, unless we can demonstrate that maybe a particular transaction in respect of which the case emanates took place in Kumasi and so on and so forth. Otherwise, you need to go to where the resides, as it were. Now, so we've talked about the parties to the action already. If in case you are wondering, like those of you who have my Ghana legal system book, you can just read chapter 6 of it. And those of you who have our senior colleague, Dr. Kwanzaa, Professor Kwanzaa, you can read chapter 12 of his work. So if you read chapter 12, Kwanzaa's book, and then you read chapter 6 of my book, these things I'm discussing are there. Then we also have the capacity to sue. You know, capacity refers to the legal competence. You cannot just bring an action against someone unless you qualify in law to be able to sue the person and all that. And where you don't indicate the capacity in which you are bringing the action, that could be fatal to the action, especially so when you are suing in representative capacity. And you all know about the Ghana Muslim Representative Council against Salifo. You read it in detail for my essential point is that where you are seeing a representative capacity, it is necessary for you to indicate so that we know that you are suing in a representative capacity. And again, issue of rate. Who issues rate? Well, rate is not issued by the parties. Rate is issued by the registrar of the court, of course, on behalf of the Chief Justice. But it is you, the plaintiff, who trigger or who requests the rate to be issued. So that is what you should keep in mind. And the rate is said to be issued when it is sealed. That is when the seal of the court is embossed or put on it. And that is very important because once the seal of the court is embossed or put on it, what it means is that it gives official authentication, official imprimatur that the sovereignty of Ghana has been deployed against the particular person. Because don't forget, the Chief Justice as the head of the judiciary, and then the judiciary having the judicial power. The judicial power is a manifestation of the sovereignty of Ghana. And for that matter, when a writ is issued against you, it's like the power of the state, which has been invoked against you, the particular person, in respect of the claims which are being made, and so on and so forth. But there are some times that before you can even get a writ issue, you need to go to court and get a permission, what you call like the leave, especially where the person you are trying to sue is living outside Ghana. Then you need to go and get the permission and all that. Another point to note is about the service of a writ. When a writ has been issued, it needs to be served. And service of it means that you need to take steps to bring the writ to the attention of your opponent. If you have issued a writ, meaning that the seal of the court has been put on it and it's just lying at the register of the court, it's really meaningless because your opponent is not aware that he or she has been sued. And because he is not aware that he or she has been sued, he cannot answer, he cannot come forward and answer your claim. And that is why service is very important. So we have bailiff. That is the court officials whose role is it to serve the writ and the other processes, other documents which are as part of the litigation. Then when you are served with the writ, then you as the defendant, you need to do something. You need to have appearance. So you enter appearance, either unconditional appearance or what they call the conditional appearance. So by unconditional appearance, you are simply saying that, yes, I'm aware of the suit which you have initiated against me, and I'm ready to answer it. Conditional appearance, or what they call the appearance and the protest, you are simply saying that I'm aware you have sued me, but I think that you cannot sue me, or how you have sued me, it is not proper, or the way and manner you serve the thing on me, it is questionable. So the court should look into it and all that. Then the person will later bring an application and let the court know. Now, just before we leave service, at the point we need to know is that we have two main types of service. We have what they call the personal service and what they call substituted service. So personal service is where the bailiff or the registered process server bring the particular court process, be it the rate or whatever, and serve it on the person who is being sued. You give it to the person or you throw it at him. Personal service. Now, substituted service is where it is not practically possible for you to effect personal service. So you get leave, that is permission of the court, to use some other means. That is what we call that the substituted service. Either you go and put it on the notice board of the court, on the known abode of the defendant, or sometimes even by publication in the dailies or the as it were. So let's keep that in mind. Because where the defendant fails to enter appearance, after you have served him, then he or she, the plaintiff, can go and get a judgment against the defendant in default of appearance. Now, another thing to note is also that we have what they call the liquidator claim as against unliquidated claim. Because those of you who do a law of contract, when we're discussing in damages, we talk about that. But when it comes to civil litigation too, the claim may be liquidated or unliquidated. Liquidated simply means that the particular sum of money for which you are suing the opponent is known, is specified. So maybe you sue someone for recovery of 500,000 Ghana cedis, or 50,000 Ghana cedis, or 10,000 Ghana cedis. So that is an ascertained sum of money, and that is a liquidated claim. And then we also have the unliquidated claim, maybe where somebody has sued for general damages, or somebody has sued for declaration of title to land, and things like those are unliquidated. You don't know the money. And because it's not known, you cannot obtain final judgment if the defendant does not even enter appearance. So that is another thing that we should keep in mind. You can only get what we call interlocutory judgment where the claim was unliquidated. Should the defendant fail to enter appearance, you can get interlocutory judgment, and later on, you have to go and then prove the claim or the details of how much the court should enter the judgment for. So you go and do assessment of damages as it were. So let's keep that in mind. Of course, we also have a claim for debt where someone has taken your goods and you need to get the value of the goods paid to you, or you need to get it. So where a judgment has been obtained against you as a defendant because you didn't enter appearance, you can later on go and explain to the court why the judgment should not be allowed to stand, and then the court would actually set aside the judgment, and both parties will be allowed to go into the merits of the particular case as it were. Another thing we have to remember in relation to civil litigation is what they call pleadings. So when we talk about the pleadings, this refers to the formal allegation by the parties of their respective claim and defenses. So the formal statement by the plaintiff that due to XYZ, or these are the circumstances in which I came to have a claim against the defendant, or in which I came to have a suit against the defendant. You explain that, the formal allegations you are making. Then the defendant too will also set up his answer or reaction, or what you call like the defense. So all those statements by which one party is making allegation against the other, and the other party is making allegation response of those allegations, we call them like the pleadings. And the idea is simply to narrow the controversy between the parties so that clearly both parties know what exactly opponent is saying against him or her, and the court is also know the issues in controversy, the issues in contention, in respect of which trial will have to be done, in respect of which evidence will have to be adduced to enable the court to actually determine who has a better claim and who doesn't have a good claim. So we have a statement of claim. Statement of claim is what the plaintiff will do. And then once of course, the rate now is accompanied by statement of claim, unlike the past. And the law has changed since 2004 when we got the CF7. Now you get the rate of summons issued. It must be accompanied by the statement of claim. And the statement of claim will narrate all the allegations which the plaintiff is relying on to look for the relief that is asking the court to order or decree against the defendant. So it is served on the defendant with the writ, and usually the defendant has what you call like the 8 days within which you enter appearance. After 8 days, you entered appearance, you have another 14 days within which to bring your statement of defense. That is, you are reacting to the statement of claim, that is allegation which the plaintiff is making against you. So you have 14 days to do that. And once your defense is served on the plaintiff also has 8 days within which to bring a reply. That is to react to the defenses that you have blocked. And once reply has been served, pleadings are said to have been closed, and the action will be ripe for application for directions of to meet the parties in court and then find out what are the key issues, the key questions which need to be addressed in order to know who wins the case and who loses the case. So we call that the application for direction, and then the issues will be set out and all that. Of course, there's only something called like the summary judgment. Summary judgment simply means that where the plaintiff is so convinced that the defendant has no answer to the case that the plaintiff is bringing against him, he can ask the court to right away grant judgment without the necessity of going through full-blown trial. And this is typically the case. If, for example, I gave you either a check or some transaction, as you have documentary proof, and it's so obvious that once you attach the documents to the application that you are bringing before the court, I just do not have any answer, or I cannot controvert it in any way. And the court can rely on it and say that my claim against you is unimpeachable, is really, I mean, you cannot bring any answer to it. Then the court can go ahead and enter judgment for you without having to go through the of a full-blown trial, as the case may be. And as I said, during litigation, a number of things may happen. You may need to go to court for some other requests. Do that by means of application, or what they call like the motion. So motion simply refers to application, and then we need to keep that in mind. Of course, we have the judgment at the end of the day. What the litigants are interested in is like the judgment. And judgment is the official decision of the court in terms of the rights and claims of the parties to an action litigated in the court before them. So what is the court decision? So the court decision on the evidence and then the law in relation to the claims which the parties are making is what we call like the judgment. So a judgment may be final or interlocutory. A final judgment is a judgment which effectively disposes of the subject matter of a controversy or determines the litigation. So that all the merits of the issues are actually resolved. So that is like the final judgment. It effectively resolves the controversy between the parties, and there's no question which is left unanswered. By interlocutory judgment simply establishes the right of a party or entitlement of a party to recover in general terms, or simply addressing a preliminary point, but which is not the end of everything. You still need to go through a full-blown trial to take evidence as it were. Yeah, I noticed, I have not read the issues you're putting in the chat, but I've very soon I'll look at some of the things and address you. Then finally, we also have to be aware of enforcement of judgment, what we call the execution of judgment. So when judgment has been given, you need to let the judgment be operationalized. You need to let the judgment be put into practice. Because when the judgment is put into practice, then you as a winning party, you as a successful party, then get what you ask the court to grant you, get the benefit of your victory. And that is why enforcement is very what? Is very important. So what are the methods or what are the strategies or the techniques for enforcing the judgment or translating the judgment of the court into action? We have ganache, charging order, rate of sequestration, FIFE, committal orders, and so on. So rate FIFE, look at the spelling. Written Fari Fascias, but we don't say that. We simply say FIFE. Yeah, so the rate of FIFE, it is a means of enforcing a judgment. By which authority is given to the registrar or the agent of the registrar, such as the sheriff and eventually the license or to seize and sell the assets of the property of the judgment debtor, which will be sufficient to satisfy the judgment that has been entered against the judgment debtor, as well as for judgment interest. That is interest accruing since the judgment was entered, and also cost of execution. So the various things which will have to be done, they all attract money. And those monies will be charged against the judgment debtor. Of course, we also have ganache proceedings. And by ganache proceedings, it is where an order made against a person who has money belonging to another person, who has money or property belonging to another person, against whom a judgment has been entered or has been obtained, and asking that person to come and show cause, to come and explain why the money should not be released by him in satisfaction of the judgment entered against the original owner or the original person who is entitled to that money. So that maybe like you are a judgment debtor and you have a money with, let's say, Absa Bank or Republic Bank or Stanchart or the Rural Bank, and we get the garnishee to be served on the manager of the bank, and he will come to court and will come and disclose information about your account, and then the court will ask the bank to show why they shouldn't be ordered, for example, release the money that they are holding on your behalf in satisfaction of the judgment that has been entered against you as their customer. That is the ganache order, as it were. yes, we also have like the rate of sequestration, and especially where judgment has been or given or has been made for maybe giving of possession of land, delivery of goods, or abatement of a nuisance, and the defendant, for example, fails, uh, then rate of sequestration may be issued against the person's property or against shares of the particular uh, company if it's an incorporated entity, as it were. And then a rate of possession, it has to do like land litigation, especially where the court has declared that someone has a title to land. Then you be given the rate of possession so that you are allowed to take over physically the land, or you are given the means to take over the land, as it were. Yeah, so these are some of the ways by which judgments are enforced. Because we do have the rate of delivery, and that has to do with the movables. Movable, that is a non-land subject matter of litigation. Rate of delivery can be made for you to hand over chattels to the winning party. Then we also have committer proceedings, what they call contempt of court. That is also another means of enforcing judgment or orders, especially when the court has made certain orders and then a person decides to defy them. Then you can move for, you can move the power of the court for the defaulting party to be punished as it were. And we also have like the appeals. When you lose a case, you are entitled to go on appeal as it were. So these are some of the basic things that we need to remember with respect to civil litigation or civil justice system. And I will maybe let's take one or two questions. So let's take an objective question like this. When we say that in Ghana, civil actions, uh, civil action, I'm teaching, I'll call you when I'm finished. All right. Civil actions in Ghana, for example, are commenced in one of the following ways, except A, rate of sermons, B, originating notice of motion, C, petition, D, warrant. What is the correct answer? Let me see what some of you put there. Question one. Okay, I think let me see if somebody will get it wrong. So far, so good. Okay, that is good. Yeah, so certainly D. And as I always indicate, last year I told your colleagues who wrote what we call the elimination method multiple choice, and I think that it worked for a good number of them. So by the elimination method of answering multiple choice question, this is how it works. Meaning that when you are giving options, most of the times you'll be able to cross out the most unlikely response, and you'll be left to just one or two, and then you need to juggle between which one is the correct answer as it were. So this one, for example, civil action comments in one of the following ways, except elimination method sometimes maybe applicable, it may not be applicable. Okay, you ask yourself, warrant. When we say warrant, what is the meaning of warrant? Okay, you are not okay. Petition. Petition, maybe you remember that originating motion, remember rate of sermons. And then you notice that as you ask yourself question, if you are not very sure, the answer is D. It could be left with only D. And that is what you choose. And even if you're not 100% sure, to still coincide with the correct answer. A written application in the nature of a pleading, setting out a party's case in detail and is made in the open court is referred to in the same thing, like the rate of summons, originating notion of notice, petition, warrant. Sure you have the answer. Yeah, but over here, I think the answers should have included like the statement of claim. Yes, statement rate of summons accompanied by the statement and things like that. I think the answers we have from the questions are not very good. So on the service of a rate of summons, the time limit within which the defendant must make an appearance in court, otherwise judgments will be given against him is 3. What are the answers? Let me see. Okay, all right, yeah. Yeah, I think all of you, your legal system is quite strong. That is true. B. 4. The parties to an originating notice of motion are plaintiff and defendant, applicant, respondent, petitioner and respondent, applicant and defendant. Which one is the answer? Question 4. Question 4. Somebody is saying A, somebody is saying B, somebody is saying C. The parties originating notice of motion are, so those who are saying A, plaintiff and defendant. Plaintiff and defendant is usually used when we are talking about rate of summons. And then applicant and respondent is used when we're talking about applications. We are talking about application, getting motion notice. So the answer should be B. C, petitioner and respondent is used when we are talking about petition. And then D, applicant and defendant is improper use of the legal language, because we usually talk about the applicant and respondent or plaintiff and defendant. Although we know if it's we know you mean respondent, but that is improper use of legal language, as it were. So the answer is B. We're talking about originating a motion on notice. So let me see, like the B. Okay, so a good number of you go like the B. 5, formal allegation by the party of the respective claims and defense, which is meant to provide notice what is to be expected at trial. 5. Yeah, let me see what you provided as answer to 5. 5. Okay. Somebody is saying C, others are saying B. Okay. So the answer, formal allegation by the party, the answer is C. You see, the answer is C. So that is the pleadings. Pleadings. Assuming we're even fortunate B did not say statement of claim, just say statement. Even if B had been statement of claim, it will say no be answer. The answer will be C. Because we are not talking only about the plaintiff side, we are talking about the parties. And so it will certainly be like the pleadings as it were. So let's keep that in mind. Let's look at just one or two before I will come to you, and then I'll take your general questions on Ghana legal system. And then at 7, we will finish because I have to teach my students internal law. Now, a party seeking to make application to a court for interlocutory reliefs, I'll do so by I don't expect you to be able to, so just ignore question 6. Ignore question. Let's go on to question 7. A writ of summons must contain one of the following: A, name of claimants or plaintiff's lawyer. B, property of the defendant. C, address of defendant. D, name of the defendant's lawyer. Question 7. What is the correct answer to question 7? Question 7. What is the answer? Question 7. Let me see. Yeah, certainly. The answer is C. That is the address of the defendant. Of course, if you said A is not correct, it's not wrong, but we are looking for the most accurate answer. We are talking about material. It's not all the time that you sue by a lawyer, and that is why A is not the answer. And then B, property of defendant. You are suing the person, so how do you, what is the point about like the property of the defendant? Then let's say D, for example, name defendant's lawyer. You are now suing the person, so how can you know the lawyer by which the defendant would like him or her to represent, Yes, the answer, I think the most correct answer will be C. Then let's look at just one or two, and then the service of a writ is usually effected by one of the following persons. A, bailiff. B, plaintiffs. C, lawyers. D, defendants. Question 8, what is the answer? Okay. Yeah, so I think that almost all of you are getting the correct answers for question 8. Yes, obviously bailiff. C, where a statute provides for making of an application to the court, but does not provide for the manner in which it is to be made, or no rules of court exist to govern such proceedings, the most appropriate way to make such application is by A, writ of summons. B, originating notice of motion. C, petition. D, warrant. Question 9, what do you think is the most appropriate answer? Question 9. Question 9. Okay. So I think those who responded to question 9, you are correct. Is B, originating notice of any other. That is true. Property or creditor of a judgment debtor in possession of a third party may be appropriately required by A, rate of sequestration. B, rate of possession. C, garnishee proceedings. D, rate of IFA. Question 10. What is the correct answer? Question 10. What is the correct answer? Question 10. Question 10. Can we get, yeah. We look at it. Look at your answers. Question 10. Question 10. Some of you have gone for garnishee. Some have gone for sequestration. Some have gone for rate of FIFE. Now, those who went for garnishee, can you explain why you went for garnishee, and those who went for the sequestration? Yes. You can put your thoughts in the chat if you want, or you can just raise up your hand and then we'll allow you. Nobody hand is up. Okay. Okay, we have a bright button. Bright button. Yeah.
Right. Yeah, Doc. I think the clue over there was the third party. And so I went for a C because the issue, the clue I got from the question was the third party. That's a clue. And that's why I went for C, Ganishi. Yeah.
And why do you think that sequestration cannot be the answer? Why? Why?
Like as I indicated earlier, sequestration does not involve a third party. It doesn't. Paganashi, all that has to do with causing the third party to come to court to explain why the property of the defendant should not be given to the claimant.
Okay. And
Yeah.
what is the sequestration then?
Sequestration, I think that one, from what I read from your book, the court will appoint, let's say, an officer of the court to hold all the properties of the defendants pending determination of the case. And so when that is done, then the court will determine whether in fact, they have to hold almost his or her entire property. So the personal effect, the charters, everything, until the matter is determined.
Okay.
Yeah.
Those who put their hand up for sequestration, can you explain? We have somebody speaking for Ganeshi. So can we get those who, some of you opted for, yes. Can we get any of those who said that is A to defend your? Okay, let's go. The vote is monetary and sequestration, relation, contempt cases, only in my opinion. Okay. All right. So since the sequestration people are not prepared to defend their answer, what it means is that the rest of the matter speaks for itself, isn't it? Okay. All right. So at this stage, I was going to let's do some essay question, but I think just leave that and just invite you to bring your questions regarding legal system before in about 20 minutes time we'll finish the class. We'll meet again tomorrow in the night. So at this stage, I will take your questions. If you want to speak, you just put up your hand and then we'll pick you. Okay, so, and please, you have to be snappy so that you can have the opportunity. So you have a very limited time. Let's do. Let's.
Hello, Prof. Yes, please, yeah, hello?
Yes, please, go ahead. Yes, Alex.
Yes, Prof, I want to know where you want to enforce, where you want to start a civil action after a criminal procedure or an action where the accused is been convicted and you are to start with a civil action by enforcement, where there was an order that the accused who has been convicted should refund some money to you. Now, I want to know how you go about that. Now, where the person is serving a jail term, do you serve notice on the person at the prison, or how do you go about that?
All right, thank you very much, Alex. Somebody had just put up a question that where do I send the link? For we coming to have the class, we have about 6 or 7 WhatsApp platforms and then the Telegram. We send the link there. And then on the YouTube too. The YouTube, you can just use and I have a channel called Law entrance examination. So when we finish the class, we try to upload it over there. So that is how you get that. So coming back to our list. So where in a criminal trial, orders have been made that there's somebody should, some, if you pay certain monies and you want to recover that money by civil action. You want to recover that money by civil, or let's say that, I don't know, if you are talking about, let's say that running that action, the court said that yes, the driver is guilty and all that, you need to go ahead and get like civil orders. You issue a writ, and then you will plead. The judgment will just become a means of you proving the claim, because the standard for, let's say, criminal trial is a proof beyond reasonable doubt. It is a higher standard than the preponderance of probability when it comes to civil litigation. So if, for example, the court has said that somebody was, let's say, guilty of driving negligently or carelessly and all that, come back to, let's say, a civil action, you need to prove negligence against the person. The criminal judgment becomes a very easy proof for you, which you can rely on, because that is a higher standard. So if the court is saying that yes, you actually didn't drive properly and all that, that will be given a very heavy weight in terms of evidential value, as the case may be. On the other hand, if you're not talking about that, and let's say that you are talking about maybe somebody has been found guilty of financial loss to the state, and the court has made that certain money should be recovered on behalf of the state, depending upon the order. If the order is the person did not appeal, the order is so obvious, then that becomes like a liquidator claim, because you know the amount. The court said that you've caused 1 million Ghana in financial loss and it should be recovered. We just take steps to have it enforced against you. But to enable it, to usually be able to channel through the techniques or the methods of civil judgment enforcement, you need to issue the rate, except that when you issue the rate, it will be for liquidated damage, and the defendant will not have any proof. So you quickly just get like the judgment, and then you have the various judgment enforcement mechanism, rate of IFA, organashid applied, as it were, except where in that particular criminal case, maybe the legislation which created it described a particular method that if in the criminal trial, certain pronouncement have been made regarding how much a person should refund to the state, there's a procedure for getting, and that one is different. And this is different from a fine. I'm not talking about a fine. A fine is a fine. That one, you don't need to go through the procedures for enforcement of judgment to recover a fine. So that one, I'm not talking about that. So thank you very much. So unless that is that, let's take Nana. Then why taking Adinana? Yeah. Somebody also asked a question, and Josephine said that is there any difference between pleading and affidavit? Yes. Pleading refers to the formal statement of an allegation being made by the litigating parties, the plaintiff, the claimant, or the applicant, the respondent, that's the case may. But the affidavit is a sworn statement. So affidavit is evidence. Affidavit is evidence because affidavit is a statement you made under oath and is commissioned before commission of oath, as it were. So that is the difference. Pleading is just allegation which will need to be proved by evidence, but affidavit is an evidence on the basis of which the court can rely and make a decision. Then another person asked a question, say, please, what does the committee appointed under what it says for the removal Chief Justice do? Please, have you read what it says? Because for removal of Chief Justice, you read the third provision. The procedures are spelled out clearly there. Where prima facie case will have to be established and all that. So unless you have read that and then you do not understand or you have a particular question, in respect of which I'll be happy to discuss. But otherwise, I would say that since the procedure is there, just take your constitution. Take your constitution and read the 146. Yeah, 146, removal of justice of superior. The procedure is the 146, especially clause 3, right? If the president receives petition for removal of a justice of superior court other than the chief justice, and so yeah. So clause 4, where the chief justice, yeah. So just go through. The procedures are there, unless you don't understand, in which case I will explain. But if you understand, the procedures are in Article 146. There's no need to belabor the point. But if you read it and you have a particular question, then I'll be happy to deal with that. I think Ella, okay. Then someone else asked the question, is there any timeline for enforcement of a judgment? Is there a deadline for the enforcement? Okay. When it comes to judgment, we have limitation of actions. Limitation of actions applies to when you have to bring the case to court. So that is what is time bound. And the Limitation of Actions Act, the various timelines, a simple contract, 6 years, land, and all that. But when it comes to judgment, for judgment, there is no timeline. Unless, of course, the only exception is that if the court has prescribed a timeline in the order, then that one is different. If the court has prescribed a timeline that something should be done within a certain time, then the timeline will have to be followed. Otherwise, judgment simpliciter. So long as the judgment has not been enforced, you can enforce it whenever it is possible for it to be enforced. Because let's say that I got a judgment against you for recovery of 10 cedis, and I have looked, you don't have any assets, you don't have any money anywhere. So I'm not able to enforce it now. It doesn't mean that I cannot do the judgment 5 years time when you get property. All that I'll do, the necessary legal step, I can enforce it against you. Even when you die, I can enforce it against your estate. So that is the thing about it. Let me take Ella. Ella, you can ask your question. Nana, you put your hand down after.
Thank you so much.
Yeah, so after.
Okay. So I wanted to ask.
Hello, Doc.
Yeah, Nana, let Ella finish. When Ella finishes, Nana, you talk.
Okay, thank you. So I wanted to know that the Constitution requires the president to, under certain circumstances, to perform functions, acting in accordance with advice of and in consultation with specified persons. So I just few cases to explain.
You mean like the Chief Justice? Is that the Chief Justice should act in consultation with the president? Or I didn't understand you well. Ella? Hello? Your network?
Yes.
Yeah. There's a bit of noise from my end. So you can put your question in the chat. If your background is not clear enough, you can put it in the chat and then we will deal with it. Okay, thank you.
Okay.
Nana, you can talk now. Okay, Nana is gone. Angela, and then Prince, Prince Nketia.
Hello, sir. Yes, please. I would like to ask, how does a person start commence an action against a person in a civil suit in which the defendant is outside the jurisdiction. So how would that person get to serve the rate of notice on that person,
Okay.
the rate of sermon on that person?
All right, Prince. Where the defendant is located outside the jurisdiction. When we say outside the jurisdiction, we are talking about outside Ghana. Then,
Yes, sir.
before you issue the writ, you have to go to court and get leave. So you get a permission. You get permission from the court for the leave to issue a writ, notice of which will be served outside Ghana. You cannot serve the writs outside Ghana. That one is against principle of international law and it's not acceptable because the writ means that you are invoking the sovereignty of Ghana against another person. Now, Ghanaian law enforcement agents cannot, for example, if your defendant is based in Germany or is based in America, cannot go to Germany, for example, and arrest the person if the person has, for example, disobeyed the orders of Ghanaian court. It's not that simple. That will be we interfering with the sovereignty of another country. And that is why it is a notice. It is a notice of the writ, which you are going to issue in Ghana. That will be served on the person outside Ghana. Yeah, so there's a procedure for that. You go for leave, and sometimes the court will allow you to either post the notice or go through the Ministry of Foreign Affairs, and then you get to the particular country. They will use the officials over there to get a notice served on the person who is based there, which you are issuing, as the case may be. So that is how it is done. Now let's take Angela. Angela.
Sir, good evening. Sir, I was asking about last 2 weeks lecture. We did not get that one on YouTube. I was asking if you could help us with that.
Last two weeks. Those who were here, what did we discuss? So that I'll go to the Zoom and try and. Last 2 weeks. I think, was that not when I was sick and then we just do a short general interaction? Was that the one? Okay, anyway, I'll go to the Zoom and try and, okay. I'll go to the Zoom, try and retrieve it and then upload it and then let you know. Or when you are a subscriber, then when it's uploaded, you'll know. Okay. So yeah, I think we've exhausted all those who want to ask questions. So let me look at it, finishing very soon. And as I said, tomorrow in the night, 8:30, we will have a class. So we'll let you know. Somebody is asking, what is the definition of homosexuality? Of course, our Criminal Offences Act talks about what they call the unnatural carnal knowledge. So we have to stick to that for now. I know some of you have put up the bill, which minority or the members of parliament are trying to push through so that we effectively say no to LGBT in Ghana. Yeah, I think it's a topical issue. I will look at the bill and then you build maybe a discussion around that. Since your examiner or examiners probably may also be following topical stuff and may want to ask you a question, something around that. So there's nothing wrong if you wanted to be creative and anticipate some discussion around that subject matter. Angela's hand is up. I don't know if you still want to talk. Angela, do you still want to talk? Your hand is up. Okay, so maybe the other advice I will give is that if there are some particular things you would like to be assisted, you can WhatsApp me and then we'll build a discussion substantively around on a forum like this. If there are some particular things, yeah. Joshua Abba. And some of you have written these exams a couple of times, meaning that some other things may be worrying you. That is why you are not passing. So just feel free and then let's engage and diagnose what your problem is, so that some of you, it's not the case you are not learning. Some of you actually learn to even understand and know a lot of stuff, but you write and you don't pass. It may just be just one or two issues you need to deal with, to be able to overcome, so that we diagnose your problem and then we help you. Somebody has
Yeah, doc.
Yes.
Yeah, doctor. What I want to know, I want to say is that most often every year they ask questions on topical issues.
Right.
Every year they ask questions on topical issues. What's trending currently in the country with regards to law? So I'm pleading if you could look at it critically for us, and then this homosexuality issue a bill before Parliament. If in case you go and then the question is about this gay and lesbians, how are you going to address it? Thank you.
Okay, so I would like all of you to read the case of the what is Oberfedel, that American case. I will put the link there for you to read the Oberfedel case before we come back to this LGBT bill and some other materials I will send to you. Okay, so that is noted. Rosie, and then Fair, and then we end. I think somebody has justice. I wanted to know. The constitution, acting in accordance with, acting on the advice of enacting consultation. Oh, okay. So acting in accordance with, if you know, there's a case which was brought between the Ghana Bar Association, right? The Ghana Bar Association and the Attorney General in relation to appointment of judges, that as whether the president is bound by advice. If the constitution is that the president should be to take advice or consultation with, what does it mean? So we will give that that decision actually eliminates these phrases which also like to so somebody is asking to share the WhatsApp link, those who are not on the page. I didn't okay, just I'll put the okay, so that is fine. Don't worry, I think we will, but the number of platforms, I'm surprised. Those of you who are not on any platform, if you go to the YouTube, just look at the number down there. You can just send information, and then we'll add you as. So as please let me take the last two questions, and then I will end. We've overstayed our time. So Rosie, no, Rosie is done. So let's take a recofer.
Yeah, good evening, sir.
Good evening.
Good evening.
Yes, go ahead. Yeah, go ahead.
Yeah, my question is, if, for example, you are writing a legal opinion,
yes,
and you state a particular clause,
yes,
are you required to paraphrase it or just make reference to it? Like, for example, MPP versus Attorney General, they went with Article 33, that's under defense of the Constitution. So you need to go ahead to state specifically what Article 33 states before you progress, or you just state Article 3 clause 3 and you just leave it and go on.
Or like as whether you should be able to pinpoint the actual what do you call it, the actual subclause. Is that the question?
Yes, please.
Okay, for me, my advice to students, especially, I'm a teacher of company law. My advice to students is that when it comes to law area, which is based on specific provisions of an act or special legislation, unless you are 100% sure, don't say Article 140 says clause 3. That one is dangerous unless you are 100% sure. If you know that Article 40 says is saying what you are saying, just say Article 40 says. Don't specify the clause or the sub clause or the paragraph, just to avoid getting it wrong. Now, those of you are asking the name of the YouTube. The name of the YouTube is Ernest Owusudapa. Just my name, and then the number is also 057 460 4820. It's usually also written at the bottom of the YouTube. And somebody is asking how many pages will be identified for entrance examination. Okay, so the question is about quantity and quality. If you're answering a question in the entrance examination, it's not so much about quantity, it's about quality. And handwriting is also important, please. I've told you, if you are like me, you've got like a bad handwriting, you need to be conscious of it and be practicing and try and make it as clear as possible. So that is one. And two, the most important thing is for you to do justice to the question. And sometimes that will mean 1, 2 pages, 3 pages, depending. It's not the quantity only which matters, but the quality as well. But if sometimes the quality cannot be achieved unless it is at a certain length, so be it. At that time, so the response may be so qualitative that even just a short length will still let someone get more marks than someone who has written maybe about 5 or 10 pages. Yeah, so there are no hard and fast rule. And what is the effect of the Supreme Court Ordinance 1876? Okay, the person who asked that question, the effect of the Supreme Court Ordinance of 1876 is that it is that legislation which formally set up the predecessor of, if you like, our Supreme Court or our judicial system, which is based and which has actually developed all this while, from 1876 up to date, as it were. So that is one thing we should keep in mind. And that was, and if you look at that ordinance, the sources of law which are applicable were stated over there. And of course, you also remember the rule in Angu versus Atta, that the customary law will have to be proved so many times until it becomes so notorious and all that. All those things, you get those ideas going back to the 1876 ordinance. But fundamentally, it established the predecessor of the modern courts that we have in Ghana. So that is what we should keep in mind. So have a very good evening, and may God bless what we have done and enable us to be able to recall what we learned and give us a clear direction so that we'll be successful ultimately. Have a very good night, and tomorrow in the night we'll meet again. Thank you very much.